colleagues, respectfully, we are still on the Allodial title. My name is Possible, and then we are still on the Allodial title. For our first discussion on Allodial title, part 1, we talk about Allodial title, we explain it, we're analyzing the case of Ohemen versus Ejay and another. This part is a continuation of the case of Ohemen Ohemen versus Ejay and another. Ohemen versus Ejay and another. So that is what we are on it, or that is what we are discussing. So this is part 2. This is part 2 of the case of Ohemen versus Ejay and another under Allodial title. So we are still on Allodial title. So don't be confused about it. This is part 2 of it. So thank you. Just recapitulating, we started from here. The 4 principles of the 4 principal method by which a stool could acquire land. And then we analyze all this. And then we continue with the main issue that was at hand. And then we proceeded with the judgment of the court. The judgment of the court. And then we analyze here. The stool holds the absolute title in the land as trustee for and on behalf of its subjects. And the subjects are entitled to the beneficial interest or usufruct thereof and have to serve the stool. So as long as the subjects are serving the stool, you can't take it away from them. Each individual or family is regarded in the broad sense as the owner of so much of the land as it is able by its industry or by the industry of its ancestors to reduce into possession and control. So if we are a family and then we have pledged allegiance to the stool, or if we are a family under a stool, the portion that we have been able to reduce into a lawful possession, you cannot come and say that you want to sell it just because you are a king, or you are a chief or a paramount chief or whatsoever. Now, we are continuing the holding. The holding says that the area of land so reduced into lawful possession. Now, the word reduce here, reduce into the lawful possession, it means that the place was bushy, trees, plants, a lot of things were there. And then the family took it upon themselves, or the person took it upon himself or herself to make sure to clear the place, to make the place become, let me say, lovable and livable. Let me borrow these words. And then establish abodement or a habitant that the person is staying there. So you can't just come and say you are a paramount chief or you are whatsoever, so you want to take the land from them. So they reduced, that person has been able to reduce the place to a place that you can live or you can do something better. So the area of land so reduced into the lawful possession of the individual or family, and over which he or they exercise a usufructuary right. I've told you that you understand the usufructuary right. It's usually called his property. So if I belong to a particular stool or a particular skin, and then I'm able to locate a land that is part of the stool, of which no one is occupying it, and then I make sure to lower or to reduce it into a lawful possession, it automatically becomes my property. It becomes my property. It cannot, saved with the express consent of the family or individual, be disposed of by the stool. So the stool, the king, the paramount chief or whatsoever, you cannot just rise up and say, I'm going to sell it out. No. Understand the principles. These are the principles. Understand the principles and the Allodial title when you're writing at them. You can't just go out and say, I'm going to sell them out. No. Because me too, I am part. No, you can't even sell it to another subject of the stool. Not to talk of a stranger. Another subject, someone who is also part of the stool, you can't sell it to the person, not to talk of a stranger. No subject of the stool is bigger than another subject. We are all subject of the stool. So if I've been able to reduce the land to a lawful possession, you can never come and say, I'm a chief, I'm a paramount chief, I'm a king, I'm going to sell it to someone. It can't be. the individual or family may assign. So provided I am the one who has reduced it into a lawful possession, I can assign or dispose of my interest in that particular land to another subject. Please, the underline word is another subject. I repeat myself, subject, another subject. It means that if I'm a Asante and I have taken the land as a usufruct, and then I'm staying on the land, right? And I'm staying on the land, right? And I'm staying on the land. I can sell the land to another subject, Asante, but I can't sell it to someone who is coming from northern region. I can't sell it to someone who is not part of the stool. So as a northerner cannot also sell his own to me. So understand it. This is the principle. It could be disposed of to another subject. Please, to another subject. So let us continue with the holding of the court. The holding of the court. The land may be sold in execution of a decree against the individual or the family, as the case may be, without the consent of the stool. Assuming I am the one who is staying on the land. So I have become a usufruct. Remember, I have become a usufruct. I told you we will analyze this again under usufructuary interest. Right? So if I'm staying on the land and now possibly I went to borrow money and then I use the land as collateral, I didn't pay. And then there's a court judgment against me that the land should be taken out of my hand. The stool cannot rise up and say that, no, but he's not the owner. No. That judgment will suffice, will hold, will stand. So understand it. And then we are saying that by he may not dispose of the stool's absolute ownership in it to strangers without the consent and concurrence of the stool. It means that for a stranger, don't forget, for a stranger, you cannot dispose of the land to a stranger. You cannot dispose of the land to a stranger. No, that one will not work without the consent and the concurrence of the stool. So it means that if you want to dispose of to someone who is not part of the stool, you have to bring it to the notice of the stool. The stool. It means the elders, the king and the elders and everything, everyone, they have to sit on it. And then they agree. So that is how it is. So let us continue with the holding. The holding in the case of Ohemen versus Ajay, locus classicus case, so far as land law is concerned. It will be repugnant to natural justice and good conscience if, while the stool can insist upon the services and customary rights due to it from the subject, it could arbitrarily deprive its subjects of the enjoyment of the portions of the stool land in their possession. We are serving you. You, the stool, we are serving you. We pay allegiance to you. We pay respect to you, the king, the chief. We pay respect to you. You call for communal labor. We come and do the work. You don't pay us. All of this. And then the portion that belongs to me, you are coming to sell it out. It won't work. It won't work. It won't work at all. It won't work. It won't work. So it is against natural justice and good conscience if, while the stool can insist upon the services and customary right due to it from the subject, it could arbitrarily deprive its subjects of the enjoyment of the portion of the stool land in their possession. How could you do that? How could you do that? Let's continue with the holding of the courts. So they can't do that. The holding of the courts. On the other hand, the only title in land which a subject can claim against a stool is the usufructuary title to the portion of the stool land in his actual possession. If he proves that he is entitled to a declaration of this title to that land. So that is how it is. I think I've explained it. So this should let you understand it even in advance before we reach usufructuary interest. So the stool or the skin is the allodial title. However, we the subjects that we pledge allegiance to the stool, we could settle on some parts of the land if only it is unoccupied. And then we reduce it to our lawful possession. And then it becomes our property. Don't forget. So, in reality, however, these latter most are actually transfers from the original acquirers voluntarily or involuntary. Example, the acquisition by conquest. I think I've explained this one to you. The transfer of ownership or the acquisition, we could have voluntary and involuntary. Acquisition by conquest is involuntary. Transfer of the title from the conquered holder to the conquering party. Owusu versus Manche of Labadi, and then Ajua Isa versus Nowabuodu. These are the cases that you could use. I think I've explained this already. We have another involuntary, which is compulsory acquisition. Compulsory acquisition. And then the voluntary, we have gift, you have purchase, we have agreement, the rest. They are examples of voluntary transfer of titles. Let us look at old ways of acquiring the allodial title. Old. It is outmoded. In those days, conquest was part. But nowadays, traditional states do not go to war. And they don't go to war. And then discovery of land by hunters. In our present state, we don't have anything called ownerless of land in Ghana here. Ownerless of land. There is no land in Ghana that doesn't have an owner. From the introductory aspect, we said that we don't have ownerless of land. Every land is being owned by someone. Our present days, how is the allodial title acquired in our present days? In our present days. By gifts, by purchase, agreement, and compulsory acquisition. Compulsory acquisition by the state to use it in benefit of all the public. That is how it is. Now let us look at the location of the allodial title. Location of the allodial title. Where is the location of the allodial title? From section 2, so that the state can hold allodial title, stool or skin, family or clan or individual could hold allodial title. These are the locations. So let us support them with some cases to see. So we have stool or skin, family or clan, state, and then we have individual. Let us first begin with the location of the allodial title in the stool. By reading the case of Jamestown, Alata stool and another, versus Sempe stool and another. Jamestown, Alata stool and another, versus Sempe stool and another. The history of Jamestown showed clearly that it was constituted by 3 quarters, namely Akumaje, Alata, and Sempe, and that their property was vested in the Jamestown Manche. Each quarter could only claim ownership to an area which was in its exclusive possession. It would therefore be wrong for any one of the 3 stools to claim for itself the allodial title to all Jamestown lands. So it means that when you look at the Jamestown land, it could be categorized into 3. We have the Akumaje, Alata, and Sempe. So if you want to talk about the town, their location or the demarcation, then you must demarcate them according to their stools. So that is how it is. The case of Jamestown, which is Alata stool and another, versus Sempe stool and another. So Alata stool cannot claim the whole 3 quarters. Sempe stool cannot claim the whole 3 quarters. 1 for each. That is it. And then let us look at the location of the allodial title in the family. Location of the allodial title in the family. Don't forget, never forget this. Ningo pram pram. Ningo land belongs to a family. Ningo pram pram. It belongs to family. So let us quickly read from the case of Amioda versus Pordia, and Amioda versus Forzi and others. Consolidated 1967 Ghana Law Report 4, page 497. Apalu J.A. Apalu J.A. This is what he said. The lands in Ningo are not stew lands, but are owned by families or quarters, and that the lands in dispute belong to the appellant's family. The lands in Ningo are not stew lands, but are owned by families or quarters, and that the lands in dispute belong to the appellant's family. It is also affirmed in Pramprams 2. So when you look at the Prampram, that case, you will see there. And then we also have location of the allodial title in the individual, in the individual, in the individual, in the individual, in the individual. So that one too, let me invite you to read with me the case of Nyasemwe and another versus Afibie Sign. Afibie Sign 1977, 1 Ghana Law Report, page 27. 1 Ghana Law Report, page 27. The holding, Nyasemwe and another versus Afibie Sign. In the absence of a counterclaim by the defendants for a declaration of their usufructuary interest, the plaintiff, one person, individual, was entitled to a declaration in his favor in respect of his allodial title to the disputed land and his reversionary right as such as an allodial owner. The rest, let me respectfully announce to your hearing that this marks the end of our lesson or our discussion on allodial title. In our next discussion, we are going to look at customary law freehold. In fact, if you look at it carefully, you could see that we have analyzed section 1 of the Land Act 2020 Act 1036, and then section 2, which is allodial title. In our next discussion, we are going to discuss section 3. Stay tuned for that lesson. Thank you. Until we meet again another time, I will say bye-bye for now. Thank you.